All right, welcome back. Our next panel is Masterclass, Managing a True Corporate Crisis or Major Internal Investigation, and this is a fantastic group of panelists for this. Let me first introduce Jason de Bretteville. Jason is a partner at Stradling, Yocca, and previously served as an AUSA in the Central District of California from 2001 to 2006. Jason, welcome. Pleased to welcome back Lori Echavarria. She's a partner at WilmerHale in Los Angeles, and she was former SEC enforcement of over 15 years, where she was Associate Regional Director and Head of the Enforcement Program for the LA Regional Office. Great to see you again, Lori.
Thank you.
Our moderator is Hashemi. Kaz is a partner and the chair of the litigation department at Wilson Sonsini, and he previously served as counsel in the SEC's enforcement division. Very pleased to welcome Gregg Peat today. Gregg's a senior managing director at FTI Consulting based in Oregon, and he's a CPA, a CFF, and also an NFL, which means he had a stint in the the National Football League as an NFL player. So welcome, Gregg. Finally, delighted to have David Zhou join us from the SEC, Assistant Regional Director in the SEC's San Francisco Regional Office and a member of the Enforcement Division's Public Finance Abuse Unit. And David previously served as an AUSA in the Southern District of New York. Welcome, David. All right, Kaz?
Thanks, Bruce. As Bruce mentioned, this panel is about a true corporate crisis, and a corporate crisis usually brings with it an major internal investigation, and the major internal investigation is usually led by an independent committee of the board tasked with reviewing the issue, and they hire counsel to lead the investigation efforts. And usually for public companies, there's an SEC investigation. So one of the first things that happens is the independent committee and their counsel touch base with the SEC, and first thing they usually say is we're going to cooperate with the SEC's investigation. So let's start with David and cooperation. After you give your qualifier, what specific items do you look for as part of the cooperation when you see a crisis happening, an internal investigation, and they've reached out to talk to you?
Yeah, thanks very much, Kaz, and I'll start with the disclaimer first. And so the views I'm going to express today are ones that I'm making in my capacity as an assistant director in the enforcement division at the SEC, but they don't necessarily reflect the views of either the commission, the commissioners, or other members of the SEC staff. And so when we get these reach outs from companies that an internal investigation has started or that there's an allegation of serious misconduct, one of the first things I'm looking for is whether there is proper scoping of what those allegations are and what the investigation is going to be looking at. And so that means to me that the investigation is going to take a broad view of any potential violations of the federal securities laws. And when the investigation is kicking off, what I'm looking for is the company collecting all of the relevant documents and making sure that they've secured the devices of all the relevant witnesses? So I'll ask to see the document retention notices that are being sent out by the company or by the special committee. I want to understand from special committee counsel what kind of documents they're collecting, which custodians they're looking at, whether they're going to be able to obtain personal devices, for instance, that people use for work purposes. I think the other thing that's important is an understanding of whether there are any bad facts initially that the company wants to share with the SEC. I think companies that are open about those things, especially allegations early on, that's always helpful to understand as well.
Are you open to hearing good facts too?
Always open to hearing good facts as well.
Good. So we've seen some recent examples of settled SEC enforcement actions where cooperation figured prominently in those settlements. Can you review some of those and what lessons we can draw from those settlements?
Yeah. There's been a number of these, Kaz, that have come out recently, and it's proving a point that Director Graywell has made over the years, including most recently, I think he gave an interview to Law 360 earlier this month, where he talks about the importance of self-reporting by a company and then cooperation by that company as well, and the possible benefits that a company may receive at the end of an investigation when we're bringing our enforcement action. So he's made those remarks for years, but now we have a body of cases that kind of demonstrate what those benefits could be. And so one of these cases recently is one involving a registered BD and IA called Huntington Investment Company. And so that company was caught up in the off-channel communications actions that the SEC has been bringing recently, where people have been using personal devices and personal text messages to communicate about IA and BD activity. And in that particular announcement, there were 16 firms that were part of that press release. And Huntington was called out specifically because they had cooperated extensively with the SEC and they had self-reported. And so the order with respect to Huntington noted that they became aware of the problem. They started remediating even before they came to the SEC. And then they self-reported the issue and then continued that cooperation as the SEC conducted its investigation. And so they were given credit in the press release for doing that, and they received a significantly lower penalty as a result. So the other firms that were part of that enforcement action received penalties of at least $8 million, whereas Huntington received a $1.25 million penalty in consideration of their self-report and cooperation. There have been a number of other cases as well where firms received even greater benefits. So 3 come to mind that I'll just mention briefly, where companies received actually a 0 civil penalty as a result of 3 things: the self-report, the extensive cooperation, and then the significant remediation that the company undertook as well on a voluntary basis. And so the first one I'll mention is a case called Klupin. It's a China-based company where there was a serious accounting fraud issue at the company. That company self-reported. It also engaged in pretty significant cooperation, including turning over documents that were based in China to the SEC, making those available to us, and also providing summaries of witness interviews of people who were based in China, outside of the reach of one of our administrative subpoenas. And so in consideration of those actions, as well as the fact that the company voluntarily decided to withhold incentive compensation from the CEO and the CFO for that time period of the fraud, those were factors that the commission took into consideration in deciding that there should be a 0 penalty. Another recent case, also out of the San Francisco office, is the View Inc., I think. It is a smart window manufacturer, and the problem there was that they understood that they would have significant warranty liability to fix defects in certain of their windows, where they would incur liabilities of upwards of $25 million a year, and they didn't disclose that. And so that company as well engaged in extensive cooperation and self-report. Some of that cooperation entailed summarizing key documents for the staff, making available witnesses on a very quick basis, including one who was traveling overseas, and also providing the results of a third-party report that had been conducted on behalf of the company. And then the final one I'll mention is a case called Black & Decker, Stanley Black & Decker, where that company failed to disclose some of the perquisites that executives have received, specifically around the use of a corporate jet. And that company as well, they self-reported that issue. They also provided summaries of the key facts to the staff and expedited the investigation that way. And so you can see the common denominator among those 3 cases, where it's self-report, it's extensive cooperation, and it is extensive remediation after the fact. And the hope is that these cases will show, now that they're out there, will show companies that there are very real benefits to cooperation, and that it will encourage companies to do that going forward.
Thanks, David. Jason, David mentioned several times self-reporting as one of the first steps. Can you walk us through self-reporting from the defense perspective?
Sure. I mean, it really is the mirror image of the staff's expectations, as David just described. So obviously, if you're asking that question, you've had some sort of credible report of a breach of some kind, and that really starts off a race. And the race is how quickly can you identify the nature of that breach with sufficient specificity and confidence to meet the staff's expectations. And so in parallel with that, you're trying to figure out, well, can I articulate the scope of work I need to do to address that breach? And can I articulate remediation? Can I start it before I even initiate that contact? And so that when you have that call, you're in a position to satisfy the staff that you understand the scope of the problem, you are matching that scope in the work you're planning to do to investigate and confirm those facts, and you're on top of remediation. And otherwise, you're jumping the gun and you're losing the race by going in too early. So I think a lot of times companies focus on, the dangers of waiting too long. There's also a parallel danger of going in too early.
Lori, do considerations differ depending on how the issue surfaces? For example, a whistleblower complaint coming in versus some other means?
I think you have to consider it is a race, and so timing is of the essence, and how the issue first surfaces may affect your timing. Obviously, if it's a whistleblower or it's a publicly sourceable crisis, something that happens to the company that is external and that people can see, then there is a clock, because either through a whistleblower, there's a likelihood that the whistleblower is going to go to the government, be represented by whistleblower counsel, that you will lose the opportunity to self-report. And losing the opportunity to self-report will negatively impact, I think, your cooperation credit. You can still cooperate, you can still get credit, but the extent of that credit may be negatively impacted. So if you want to get the full credit of self-reporting, you are in a very, maybe sometimes rapid race, depending on how the issue first surfaces, whether it surfaces through a whistleblower or through a publicly available source. And then you have to really get your arms around the size of the crisis and the gravity of the problem as quickly as possible, because again, you don't want to go in and self-report too early on something that may not be a serious or grave issue. Where there's allegations or issues that may be entirely without merit. So you do want to figure out as quickly as possible how serious this issue is.
And Jason, what about cooperation beyond just self-reporting? Lori mentioned that's an important step, but not the only step. How, in your experience, can companies show that most effectively?
Well, obviously, there's been a increased emphasis on pointing the finger. Who are the culpable individuals? I think the staff is increasingly expecting companies to share, or at least counsel to share with the staff their understanding of who is culpable and what's being done about that. I think that's particularly problematic, obviously, for companies to deal with, and surrounding issues of privilege that we'll probably get into later. But to my mind, that's probably been the major shift in the last 10 years, is the emphasis on pressure on the company to identify culpable individuals.
Gregg, can you talk from the forensic accounting perspective of how companies balance conducting a thorough investigation that meets the various constituencies, expectations, and managing other factors such as costs of an investigation that are often important to a company and a committee of the board?
Yeah, so the primary factors that really compete with thoroughness are time, typically limited by filing deadlines and the like, and costs. And I think that the two kind of foundational investments that can be made to get that balance between efficiency and effectiveness are, one, clearly defining the investigation scope. So the upfront time and investment made to plan together with counsel, the board, or the special committee, as the case may be, is really critical. Delays and costs occur when the scope at the outset is either too narrow or too broad. And the second is just choosing the right investigation team. So making sure that team has the requisite experience, expertise, capabilities to address, the issues in the initial scope of the investigation and beyond. As I think we all know, investigations can be iterative, and you may unearth some issues that weren't part of that initial scope. So bringing to bear a team that has the capabilities to address, the broad circumstances, whether that be digital forensics, e-discovery, cyber, et cetera, is important at the outset to, maintain that thoroughness while keeping with the efficiency that's required to meet those deadlines and achieve those costs. But ultimately, thoroughness, prioritizing thoroughness, I think, outweighs the costs of doing so. We've seen that time and time again. It demonstrates that the company took the action seriously, thoroughly investigated it, and can certainly facilitate a more favorable outcome with David.
David, one last thing before we leave cooperation. Can a company receive cooperation credit that does everything right, self-reports, cooperates, provides witness interviews, but at the end of the day, there's a legitimate debate between the staff and, say, the company counsel about there was an actual violation. And you go through that whole process. The company ultimately decides to resolve it. But there's been a good, healthy debate among the staff and defense counsel whether actually an enforcement action is warranted. Can the company still get the type of cooperation credit that we've been talking about?
I think so, Gaz. We at the staff, we always welcome a dialogue with company counsel. And so that includes not only hearing about bad facts that have been unearthed, but as you mentioned earlier, good facts that are positive for the company. And we also welcome hearing about the company's perspective on the law and whether the facts that have been uncovered fit a violation of the federal securities laws. We want to make sure that we get it right. And so there are lots of points along the process where those kind of conversations can happen. They can happen informally. They can happen during a Wells process. I don't think having a real discussion about that would impact the type of cooperation credit that a company would receive. Now, I'll say that if there are obvious violations and there are clear problems, then it helps if a company is not trying to make arguments that don't make much sense, and that they acknowledge those kind of things. That goes a long way, and that helps expedite our investigations. But if there's a real debate about whether conduct that was unearthed actually meets a violation of federal securities laws, we want to hear about it.
Okay, great. Jason, companies also face disclosure issues when something like this comes up, public disclosure issues to investors. Can you discuss some of those decision points for the group?
Sure. I mean, obviously, there's no general obligation to disclose the existence of an investigation, and there are particular sensitivities about disclosing the existence of an SEC investigation or subpoena in particular. As outside counsel, you'll often have pressure from an issuer to make a disclosure for one of two reasons. I would say that possibly illegitimate reason is to speak to the market about the nature of the investigation or the issue, and that's obviously something you try to discourage as much as possible. The other are more legitimate considerations about, for example, if the company is in the market with an ATM or a HELOC and needs to trade, obviously has to discharge the MNPI that might be reflected in the investigation or the breach itself. And so it's really a balancing question of what are the various stakeholders, what will disclosure do to your relationship with the SEC, how will it impact your investors. But generally speaking, it's hard to talk about it in a general sense. But I think that usually the conversation with the client goes along the lines of, well, they want to disclose something in some circumstances, but they can't disclose it the way they want to. So you ultimately decide not to disclose in light of that push and pull. But eventually you can have pressures from the outside that then impact that conversation. So if you have parallel private litigation, that might impact your decision to disclose and when. What type of filing is it going to be in an 8K or in a quarterly filing? I typically don't like to see it in an 8K. What you disclose can impact or create an ongoing obligation of the market to update, which you don't want to take on. So the contents of disclosure really impact your go-forward obligations to your investors. So it's really a complicated question that involves a lot of stakeholders. But ultimately, I think companies try to disclose in a way that is a just the facts type of disclosure that avoids impacting the investigation and avoids taking on an obligation to reiteratively report to the market exactly what the stage of the investigation is and what's going on.
Lori, let's hypothetically say you represent a company that is preparing to go public, and the company becomes aware of an issue that might require self-reporting or decide whether to self-report or receives a broad SEC subpoena out of the blue. How do you manage that situation given where the company is in its life cycle?
I mean, essentially, I think this is where you have to have a challenging conversation with the client and constituencies within the client, because I would encourage a client to treat their situation as if they are a public company because they are on the verge of going public. It does depend a little bit on where they are in the scope of that and how the company has been capitalized up to that point. I think one of the things that you want to reinforce with a private company is that the way that they've raised money in the past, even if it's through private placements, can be the source of its own SEC investigation. And the SEC has brought cases, obviously, against privately held companies related to representations that they made while private to investors in that company. So really, you still have to deal with a lot of the same disclosure issues, even if the company is not public yet, as you would have to face once they go public. The closer they are to trying to go public, the more important it is that you confront it as if they're already have those obligations on themselves. And I think that can sometimes be a challenging conversation with clients who are in this transition because they're growing towards becoming a public company and are not yet used to taking on necessarily. Management may not be used to taking on all of the obligations of a public company yet. But I think it's important to start that dialogue with them, and then consider whether to disclose and whether to self-report and how to deal with the issue from the perspective of, okay, assume you're public, what would your obligations be and how would you deal with that?
Gregg, another issue that's coming up more and more often are short seller reports that cause companies to react, sometimes in the form of investigating the issue. Can you give some perspective on that scenario?
Yeah, I mean, I've generally seen a fairly robust response by boards when evaluating and investigating issues raised by short sellers. I mean, the approach, an ultimate decision to investigate typically involves three primary facets, one of which, whether the claims are actually legitimate, right? So do they align with the company's kind of bearish positions or issues, align with concerns that investors have raised in the past? Whether the allegations are based solely on public information versus insider information via whistleblower or employee, et cetera. The second is the short seller's credibility. So taking a look at the short seller's track record, previous campaigns can help inform the credibility of the short seller itself. And then, of course, the street's reaction, trading volume, share price, what's being communicated to the board, to the company as far as, from investors. These factors are then, of course, weighed with whether launching an investigation would just add fuel to the fire in these situations in particular. So shining a light on the short seller report, giving it undue credence. But ultimately, if an investigation is deemed necessary, a robust response with the right team is really critical to separating fact from fiction in what can be a very wide-ranging and sometimes rambling allegations in short seller reports. So, that's how I think they're generally approaching it.
Lori, how about you from a defense perspective on these short seller reports?
So I think short seller reports are everywhere, I feel like, right now, and they are driving, as you said, a very robust reaction from boards. I think you have a lot of risks related to responding to a short seller report. They are public. They have a market impact. They sometimes drive, trolling depending on the market impact. They can drive trolling for private securities actions that can get filed pretty quickly thereafter based on stock drop and stock impact. And then you have to recognize that regulators and government attorneys often treat short sellers as truth sayers. They do think that the short seller is likely to have come upon something that is worth looking at. So even though the company really may want to say, that short seller is totally wrong, they're engaging in market manipulation, they're driving the stock down for their own purposes, and there may be an element of truth to that, a company still has to really dig deep and take the short seller report seriously to address both the fact that the government is likely to take a look at the allegations, and there are likely to be private securities class actions if there's been a serious market impact caused by the short seller report. Counseling clients to resist the temptation to dismiss it out of hand or, kind of not undersell how significant the need to look into the allegations are. And then the time pressure, the race against the clock has begun.
David, how do you approach a short seller report when it comes across your desk? Because that does cause a reaction in the market sometimes. It's a lot of attention, can cause a crisis at a company that they're reacting to, and then may come to your attention.
It's one of the many types of tips, complaints, and reports that we consider when we're thinking about what to investigate and whether there's a basis for us to begin an investigation ourselves. And so when we see a short seller report, we'll analyze it pretty carefully, and then depending on the allegations, that may inform us reaching out to the company to ask about that, reaching out to the short seller to get more information from them if they're willing to provide it, and opening an investigation of our own.
And then a crisis often, Lori, brings also the company engages PR firms that come in and they have a slightly different lens on how to approach the issue than a lawyer does. Can you give the group your perspective on dealing with PR firms in a crisis situation?
Sure. I feel like all of my comments have been like the negative side of commenting. So I'm going to try I'll try to turn it positive. But I think PR firms can have a positive impact in some instances, but it's really important to be careful about how soon they go out. Clients like to respond to short sellers. They like to respond to public allegations. CEOs do not like to sit there and take, public criticism of their company without any kind of response. And it may be ill-advised to rush out with an immediate response. You need to understand the facts. You need to evaluate the disclosure issues that we've talked about. You need to deal with and address the government interests that may occur. And there may be litigation risk, frankly, in responding right away. So PR, you have to kind of work with a PR firm with those considerations in mind. Also, responding to press is not privileged. That's not legal advice, and there's case law on this. So that's another point of education around trying to make sure that the client understands and the PR firm understands that press advice is not legal advice, and there are jurisdictions where discussions with PR firms, even when they're retained by outside counsel, can become discoverable. So you just need to deal with them a little bit through that lens. So I would say emphasize factual development before responding to the press, and be careful about how you share information with your PR firm. Those would be my pieces of advice.
Jason, your experience with PR firms?
Frankly, the criminal defense lawyer in me shudders with fear at the mention of a PR firm, but there obviously are circumstances where there's a legitimate need for PR work, whether it's in the short seller context or sometimes the product liability or environmental disasters. There really are many legitimate reasons to engage a PR firm. I think one of the first issues is to separate PR that relates to the event itself as opposed to PR that relates to the investigation. I think there's almost no circumstance where you want the PR firm talking about the investigation as opposed to the facts of the event itself. So I think that Sergeant Friday approach of being the gatekeeper as counsel to avoid statements that will harm your relationship with the staff, that will impair your ability to defend the company going forward, either in private litigation or with the government, are the critical aspects. But I think it's always it's very easy, I think, as a former government lawyer, just to want to say no and to be the negative person that Lori's fearing to be today. But I think, increasingly, I think outside counsel is aware of the benefits of a PR firm in certain circumstances. And while we can't abandon our role in protecting our client, we can't just say no reflexively. It has to be a considered, a balanced approach to it.
Gregg, we have entered the plug portion of our panel. I believe FTI has a PR arm. Tell us your perspective on this.
We do, and I won't call it a PR firm. So I would describe it as a strategic communications group.
Yes. The first part of the plug is very different.
Exactly. A seasoned communications team, I think, that has experience and regularly works with counsel on investigation is not thinking about the short-term wins, right? They're thinking it's a no-win game. So they're thinking about the long-term, which is really best served by communicating the facts, if communicating at all is necessary, and then really thinking about the board's and the company's long-term reputation, which, to your point, I mean, it's an emotional event. It happens. People's knee-jerk reactions is to want to respond immediately. That is not our group. And that's not the tact, obviously, that we all know should be played. So strategic communications, good. PR firms, bad.
Got it. So staying with you, Gregg, talk a little bit also about the auditors and the forensic shadow teams that auditors bring on in these crisis situations with a major internal investigation and interacting with them.
Yeah, so the credibility of the forensic team in the eyes of the shadow team is really pretty paramount as the investigation process proceeds. The shadow team is essentially evaluating the investigation team and evaluating the investigation process such that the audit team can ultimately rely on the investigation's conclusions. So establishing credibility in that relationship at the outset can go a long way to making the entire investigation process more efficient. They will have questions. Oftentimes, both the audit team and the shadow team will have to report up to a national office. And so they'll want to get their bases covered by, asking probing questions, making sure they understand all the facts. A lot of times, documentation may not be provided to them, at least work product, right? So a lot of this may be communicated verbally, but making sure that you answer all their questions completely and accurately. If you don't know the answer to something, say, we'll get back to you, actually get back to them, can go a long way in establishing that relationship and credibility that'll make the whole process more efficient.
David, you mentioned what you kind of expect at the beginning of an investigation. What kind of things should committees and their counsel know that are not a good way of starting the interactions with the staff on a crisis arises? You're in communications with them. You talked about the self-reporting and getting facts out, the bad and the good. But what are the things that you see that are like, that wasn't a good way to start off, and we may not need to, jump into this sooner rather than later?
Yeah, that's a good question, Kaz. I think when the special committee or special committee counsel, when they're open with us right from the outset, having a productive dialogue with us, I think that always leads to better outcomes, both for us and for the companies. It's very helpful for us to understand at the outset what the allegations are and how the company is going about investigating it and whether they're scoping it appropriately. We are going to proceed with our investigation. We're not going to wait for an internal investigation to be completed. Those can often take a significant amount of time. But we also look to the internal investigation. We look to see how thorough we think it's going to be. We look to see how candid special committee counsel is going to be in kind of assessing what steps we should take in our investigation while the internal investigation is pending. And so I think where the special committee is closed in not providing details about their investigation, not providing us with updates about who they're talking to, what kind of documents they're collecting, I think that just makes it more difficult for everyone involved. And it makes it more likely that we're going to take a lot of affirmative steps ourselves to push forward our investigation.
And then talking about documents, what's the off-channel communications come in the mix, ephemeral messaging? When you hear of that, how does that, impact you? Pretty positive reaction to those?
Hearing about off-channel communications,
does that cause you to take more immediate steps or thinking of we need to do something ourselves here?
Yeah, it's a great question, Kaz. Everybody out here knows that the commission has brought a number of these off-channel communication cases that have involved registrants, so investment advisors and broker-dealers, people who are using personal text messages or emails to communicate about their work activity. That's a little different from what we're going to talk about here, I think, with public companies where there's an internal investigation happening. There, our focus is really on, are people using their personal devices to talk about issues that are going to be relevant to the internal investigation? And what we want to understand is, can the company reach those devices? Mm-hmm. Can they collect them, image them, and do a thorough review for any work-related activity and be able to provide those documents to us later on? If the company, for some reason, isn't able to reach those devices, then that means we likely will have to take our own steps to make sure those devices don't go by the wayside. I mean, we all know that these days, communications that used to happen only exclusively in email are now happening through Telegram or Slack or through other instant messaging apps.
Right.
And so it's becoming increasingly important for us to be able to get those communications.
So you would want the council to tell you, like, these are the devices we can get, but there's this policy the company has, and they're not making available to us, these individuals, and that's when you may decide you have to act.
Exactly.
What about you, Lori? How do you approach the device and ephemeral messaging and BYOD policies that are out there?
I mean, look, we have to counsel clients that the government does continue to focus on these devices and these communications, and that the government, both the SEC and DOJ, are going to ask for pretty deep preservation requirements at the start of any crisis investigation. They're going to want everything to be locked down and preserved. And we've seen, I've seen a trend of written representations from the company or from counsel, or an ask to show and share your preservation documents with the government at the outset of an investigation. So that's the first thing, is that we just have to lock down and preserve communications wherever they may reside that are relevant to the topics that are in the scope of the investigation. And in my theme of being the negative naysayer, I guess this morning, or deliverer of bad news to clients, this is always really warmly received. Like, your executives have to give me their cell phones, or preserve their cell phones, or stop using Telegram or Signal or whatever, and go into those apps. And actually, I've learned through some experience that all of those apps have a mechanism by which you can toggle off the ephemeral nature of the app. So you can go into Signal and turn off the delete after X number of minutes, hours, days, months to preserve. And so you have to have that conversation up front about preserving. Whether you collect or not is maybe a different issue, depending on what is alleged and what you're investigating. But you do have to have the hard conversation about preserving up front. And then if you have to collect, then you collect both personal and company devices. But I counsel companies to have a really clear document retention policy, and have a really clear articulation if it's a bring your own device kind of situation, that even in a bring your own device situation, if you're doing work for the company on that device, you may not have a right to privacy over the device, or certainly the work that you're performing. And companies need to be really clear and have clear policies, so that if a crisis happens, they can turn that policy over to the government and say, we have been very clear about this. We've asked our employees to, send an email or attend a training or do a certification, and this is what we're asking our employees to do, so that then whatever the employees have done or not done is somewhat on the employees, but the company is clean.
I'll jump in here for a second. I think this is one area where practices are becoming clear with respect to what best practices are for treatment of ephemeral communication systems and companies' allowance or policies for personal devices. But I do think this is an area where there's the strongest disconnect between practitioners and clients about expectations of privacy, and even fundamental questions about, is there a value to ephemeral communication? Like Bitcoin, or does crypto actually have a legitimate purpose? Do ephemeral communications have a purpose in business? Or is the staff's expectation that everything should be recorded and preserved a valid expectation? I don't want to say I would predict where that goes, but I do think that I wouldn't be surprised if there's increased litigation and chafing over the notion that every business communication needs to be made in a permanent fashion and retained and made available to law enforcement or the SEC staff whenever there's any kind of inquiry. I think we've taken the position for the last 5 years that, yes, we absolutely have to do that, and we're developing best practices around that. But I think, we did have a period where we were concerned about privacy in the 60s, and we had Title III. We took steps to avoid, unfettered access to communications. And at some point, the efforts of lawyers like me and the staff to preserve everything will trigger those privacy expectations and values that we have had more generally. And we'll see some line drawn where we'll know, there is a legitimate place for ephemeral communication in the workplace. And if we can define that space in an effective way that doesn't completely undermine law enforcement interests, that we may see some shift in how things are done.
Let's end with individuals. We've talked about special committee counsel, company counsel, crisis arises, internal investigation. Jason, you're representing a senior executive that's implicated, and the committee's counsel comes and says, we want to interview your client at least once. Let's start at the beginning. We'll do it in the middle. We do it at the end. And there's an SEC investigation. And I saw Izzy here earlier, and Izzy's office is involved too. How do you approach that scenario?
Well, I think one sort of predicate or threshold question is, why am I there? how did it come to pass that this executive has separate counsel? I think there's always the concern or the reality that my presence as separate counsel is indicative of some kind of conflict between the company and the executive, and that may or may not be true. So I think one thing to consider is what is the staff's reaction going to be to my presence? Is that an impediment to my client's ability to communicate through company counsel, or now is it solely my responsibility to interface with the staff about the content of their knowledge? But if you could sort of refocus me back on the question about
this question, if you're representing an individual and there's a request for an interview coming, how do you approach
the interview
that?
itself. Well, I mean, obviously, if you're a current executive, there's a huge amount of pressure, and the client typically is going to want to cooperate and make themselves available to that interview. And if they decide not to, there's going to be dire consequences likely for their role at the company. Obviously, if there's actual criminal exposure, the instinct of most lawyers in my position is going to advise a client not to speak to company counsel or to the staff or to law enforcement. But as in all circumstances, it's a balance between what are the benefits of cooperation versus the benefits of remaining silent. And I think the most fundamental question is are you willing to engage in the marriage that is cooperation? If you make that decision to speak, then you really are deciding that the best course for you long term is to cooperate with the government on all levels. And if you're not willing to make that commitment, you can't make that choice halfway. You can't be a fence sitter where your client will sort of cooperate and take it as it goes and decide later on exactly what makes sense. Either we're going to cooperate fully from the get-go, or we're going to withdraw into a fully defensive position.
Lori, now take that same hypothetical, but now as a former senior executive that might not have the same pressures that Jason was talking about being the current. Is it better when you know there's an SEC and criminal investigation ongoing to respectfully decline, or does that send the wrong message to the government?
I mean, I think that it may be that you're in the best situation to respectfully decline, but it depends on where you're working at the time. So if you're a former employee and you've gone on to some other public company, your new public company and its auditors will care if you are not if you have been identified in some way in connection with conduct at your prior employer and you're not cooperating with the government, and that comes out. You may have obligations to tell your new employer that you're responding to this inquiry from your old employer. And so there can be very complicated kind of privacy and confidentiality concerns around those communications, because if you feel obligated to tell your new job about this or your new position about this, that could be revealing information about the existence of an investigation that is not yet public related to a different public company. So this can be actually a pretty tricky area to navigate for former employees.
So David, maybe we'll end with you. You learn that a senior executive has counsel, individual counsel, I think is their right to have. Does that have a negative implication? And second, if not, having declined to sit for an interview, does that have a negative implication for you, or you just then take your own steps to speak with the person yourself?
Yeah, I think as the others on the panel have pointed out, everybody's entitled to have individual representation. We don't view that negatively at all if somebody chooses to have their own counsel that's separate from company counsel. Now, if we learn from the special committee counsel that an executive has declined to sit for an interview with that special committee during their investigation, certainly that's an interesting fact to us. And we have our own investigative steps that we're going to take, which often entail talking to former executives and current executives in order to understand what happened. And so it's an interesting fact to know, but we still have our own investigative steps to take and kind of separate and apart from what happens with the internal investigation.
What do you mean it's an interesting fact to know?
Interesting,
like that's neat, or interesting and not so neat.
Well, look, I think as you pointed out earlier, Kaz, oftentimes with internal investigations, companies and special committees will give us readouts of what the interviewees have said, and so we won't have the benefit of that when we go into testimony ourselves.
Yeah. Well, that's what we have. Thanks, Bruce.
Great job. Thank you all so much.